are at least 4 EU countries that applies to. I'm not going to tell you what they are now. You'll need to phone Chambers to find out exactly what those countries are. Now, what issues should be raised at the initial hearing? Now, this is a dilemma for most of you, that if you're having to look at a warrant and find out what are the issues to be argued, should you raise them then, or should you request an adjournment so that you can consider them at a later stage? Well, for those of you that have experience in doing this work, the district judge will almost certainly push you to disclose what the issues are, or if there's anything which is apparent. I would urge you to resist this as much as possible, because if you don't raise it there, you say there are no issues, and you try to raise it later, you'll be criticised for it. If you try to raise issues, for example, Article 8, Article 6 of the Convention, the judge will want to know why. You can't just throw it in the air and say, we think there are fair trial issues, or there's right to family life issues. The judge will want to know what they are, and he may push you to argue them at the initial hearing. Again, if I'm prosecuting, I will almost certainly agree with the judge and try to have it argued at the first hearing. So you need to resist that, so you take full instructions and a proper examination of the warrant and the requested person's personal circumstances as to whether there are any Article 8 issues to argue. One of the areas which is frequently causes difficulties is explaining the effect of consent to a requested person. As you'll see from the Extradition Act, there are particular warnings that need to be put to the requested person so that he understands what the effect of consenting to be returned actually is, so that he can make a decision on whether he will consent, or if he doesn't want to consent, but there are no bars or human rights to raise, that you just have an uncontested extradition hearing. Almost certainly, acting for the defence, I would never advise a requested person to consent to be returned unless there is some reason for why he wishes to be returned promptly, and he is 100% certain that there are no other matters waiting for him when he's returned. Now, this crosses over into the protection of specialty, which, looking at the Act, is another thing that you need to be aware of, whereas specialty under the Act is not as we understood it to be under the 89 Act. There is a procedure in the Part 1 cases in particular, once a person has been returned, that new matters can be put to them once they have been returned, which would seem to render the protection of specialty superfluous. Again, you need to be aware of what that procedure is when you're advising your client what's likely to happen in the event that you lose and he's returned. Now, looking at when the court will adjourn the hearings, now the difficulty that you have is that the majority of the judges are dealing with 10-15 cases per day, and this is supposed to be a fast-track process. They will be very reluctant to adjourn matters so that you can find evidence, so that you can instruct an expert, and it has to be properly argued. Legal aid during the early stages is a valid reason for adjourning the hearing, but it will not be a valid reason through the passage of time. What the district judge may say to you is, well, he's represented today, so let's do it today. He might not get the legal aid on the next occasion, and so it's better that we proceed when he's represented. And again, they will force you to do it then. Time limits is obviously a very important aspect of the Act, and you need to be fully aware of those. First of all, the time limits at the initial hearing. Now, again, these are as soon as practicable, but you need to look at the authorities to read into them for what those time limits actually are. Frequently, you'll see that the prosecution makes a mistake in not requesting that the extradition hearing is opened within 21 days. They may have forgotten to do that, make a very clear note of everything that's said at the hearing to ensure that it has actually been opened within 21 days. I'm not suggesting you prompt the prosecutor, because that's a that's a ground that you can rely on at a subsequent date for discharge. And cases have been discharged for failing to be opened within 21 days. Time limits set by the court. Now, this refers to a proof of evidence, a skeleton argument, and expert reports. Now, they're not obligatory, they are aspirational, but it depends on the judge you're in front of. The judge may choose to disregard your submissions or your counsel submissions on the basis of failure to comply with his prior direction. It's not uncommon for that to happen. Again, we've mentioned legal aid and expedited process. Adjournments to obtain evidence. Now, you will not always be successful with such applications, as I can tell you from the painful experience of my recent defence case. Again, I had a relatively strong Article 8 argument to make. I had requested an adjournment in order to obtain a psychiatric assessment, a social work report of the family unit, and an assessment of the two handicapped children to show the effect of the husband's return to Poland. That was refused. Now, it was refused on the basis that the case had been before the court for 3 months already, and that evidence had not been obtained. I was successful in obtaining adjournments on the first 2 occasions, but not on the 3rd occasion. So once you do have the adjournment, you've got to ensure that you get hold of this evidence so that it can be presented. Adjournments to obtain further information, that's from the other side. That's what the prosecutor will be applying for. Every time you raise or you present evidence as to a particular bar or human rights matter that you're going to raise, the prosecution will almost certainly request an adjournment to send a request to the requesting state to respond. Unfortunately, as you may be unsuccessful in obtaining an adjournment for obtaining that evidence, the prosecution will almost certainly be successful in applying for an adjournment to send that back to the requesting state. Then the final matter, which is something that you have to be very, very aware of, is time limits on appeal. Now you'll see that the time limits are very short and very strict. Appealing from the magistrate's court to the administrative court is 7 days. That includes the day on which the extradition hearing was heard. So in effect, it's 6 days. Recently, the defence case that I ran, we finished at 5:30. I had 7 days, and that was the first day, so I had 6 days. The difficulty that you have, it's not 6 days to submit your grounds of appeal to the administrative court, because you have to submit your grounds of appeal to the admin court in 5 copies so that they can return it to you, so you can then serve it on the CPS and the magistrate's court. So you've got to be thinking about serving your grounds of appeal within a day or 2 of the hearing. And there is no discretion. If you are late, you will not be extended, you will not be granted an extension. There's a very clear authority on this, which was from last year, where 3 minutes late was not accepted. We've already looked at whether it's an extradition or a transfer, and certainly in the Part 1 cases, it is almost certainly a transfer. It is a very quick process. There is a tendency to look at EU countries, Council of Europe signatory countries, with mutual trust and recognition. Now, we may not consider countries such as Lithuania, Latvia, Poland, where the majority of the requests come from, as having the same standards of fair trial as we do, but unfortunately the courts look upon that in a very, very different light. It is very rare that you will succeed in an Article 6 argument, an Article 3 argument, or even an Article 8 argument with a Council of Europe member state. Bar of triviality, as we've already seen, is no longer there. Now that may return in due course. The present government is currently reviewing the 2003 Act with a view to withdrawing it, replacing it, amending it. At the moment, we don't know what they're intending to do, but that's not likely to happen for the next 12 months. As I said, fair trial guarantees. Very, very difficult to argue with Council of Europe member states. Prison conditions, the door has almost effectively been closed as a result of a series of decisions from the administrative court over the last couple of months. A number of cases concerning Poland were taken to the admin court, and the admin court has effectively said that the argument is to be raised in that country where you're being returned. It's not for this country. Now that raises an interesting argument under the effect of Section 21 of the Extradition Act that says the judge is required to consider whether return is compatible with a person's human rights. The administrative court is effectively saying the judge does not have to consider Article 3 in terms of prison conditions. Recently, in a Lithuanian case, the administrative court has accepted that in exceptional circumstances, the court should inquire into the conditions for a particular person's return. But again, it is in exceptional circumstances. In a case recently, the defense argued that in Malta, a person's detention would breach Article 3, not because of the prison conditions by themselves, but because of the length of time he would be detained pending trial. And in order to establish that argument, a number of expert reports were submitted that showed that the length of proceedings, the length of detention in Malta exceeded the requirements under Articles 5 and 6 of the Convention. The Magistrates Court refused to accept this and relied on the recent authorities that they are not required to consider them. So that, again, this is effectively closing the door to any argument under Articles 3, 5 and 6 until the Administrative Court or the Supreme Court changes its position. It's likely that they will, but unfortunately all the cases that are waiting until that point, you're not going to be able to raise those arguments, and that is the concern. One of the concerns also is whether there is a presumption in favour of bail or custody, not just in this country, but primarily in the returning country. A large proportion of these cases are accusation, not conviction matters. The argument is frequently being raised that upon return, that person will be detained almost certainly. Unfortunately, the court is refusing to hear argument on this because it is purely speculative to say whether a person would be detained or not. So what can you argue? If you can't argue any human rights points, what can you argue? Well, the majority of the arguments that are made concern the validity of the warrant, and that's the first thing that you need to be looking at. And you need to look at this by reference to the Act, particularly Section 2 of the Act, but also you need to look at this in a very common sense approach. By looking at the warrant to see whether, in your view, it is sufficiently particularised. Whether it's an accusation or a conviction. If it's a conviction warrant, then the court will look less into the particularisation than if it was an accusation offence. But you nonetheless need to consider. For example, there is a tendency